Director of Public Prosecutions, prosecutions against Bank of Baroda and others.
The National Director of Public Prosecutions brought an urgent application for orders to preserve certain monies and an immovable property in terms of the Prevention of Organised Crime Act 121 of 1998. It was alleged that the property was used as an instrument of crime in a corrupt scheme to siphon state funds out of the Free State Department of Agriculture and Rural Development under the guise of a dairy farming project. The operation of the farm was to be administered by a company, Estina Pty Limited, in terms of an agreement entered into by the department and Estina. The sole director of Estina at the relevant time was one Kamal Wasram. The application was granted and the orders set out in a draft order prepared by the applicant with some amendments were granted ex parte by me on the 18th of January of this year. Some of the affected entities now applies for the reconsideration of the orders affecting them. I will refer to the National Director of Public Prosecutions as the applicant or DPP and the parties applying for reconsideration as the affected parties. When the matter served before me initially, I was satisfied that there were sufficient factual averments to justify a reasonable belief that the immovable property was instrumental to the crimes of corruption and fraud, and that the payments made to Estina by the department constitute the proceeds of unlawful activities. None of the affected parties in their applications for reconsideration questioned the aforesaid findings. The sole attack on the specific orders concerning them is based on questioning the alleged link between payments they have received out of the account held by the Bank of Baroda in its Nedbank account and the payments made by the department to Estina, and portions of which were allegedly transferred by Estina to the aforesaid Nedbank account. When the matter served before me initially, being an urgent application consisting of some 950 pages, I heavily relied on the veracity and sufficiency of the evidence deposed to by the deponent, Mr. Maradla. Mr. Maradla described himself as a highly qualified forensic investigator who based his findings on a thorough investigation of the flow of funds from the department to Estina and from there to the various affected entities or persons during the period April 2013 to July 2017. More particularly, Mr. Maradla relied on his investigations of Estina's bank accounts held in the Standard Bank and First National Bank, as well as the account held by the Bank of Baroda in Nedbank. Apart from the copies of the said accounts annexed to the papers, he mentioned that he is in possession of 8 lever arc files detailing all the financial transactions, which files are available but not annexed, so as not to burden the application with further voluminous annexures. Mr. Maradla then details the results of his investigations, identifying 7 tranches of payment received by Estina from the department, and sets out the further flow of funds from Estina to various persons and entities which allegedly constitute the proceeds of crime. He then differentiates between payments made by Estina to farming-related entities and payments made to entities not so related. The latter entities are then identified as affected parties in respect of whom preservation orders were sought and granted. Some of the entities in respect of whom preservation orders were granted was paid by Estina directly out of either the Standard Bank account or the First National Bank accounts. Insofar as such payments were not farming-related expenditure, there can be little doubt that they are suspect and constitute reasonable grounds to believe they relate to proceeds of crime being disbursed to such entities. The affected parties who apply for reconsideration are, with two minor exceptions, all entities whom allegedly received payments of proceeds of crime through the intervention of the Bank of Baroda. The two exceptions being an amount of 157,320 rand paid from the Standard Bank account of Estina to Linkway on the 8th of May 2013 and an amount of 73,277 rand and 24 cents paid to Aerohaven on the 30th of July 2014. I deal with these later. It is prudent to start with the position of the Bank of Baroda. The position of this bank stands on a somewhat different footing from those of the other affected parties. The bank explains in its application for reconsideration that the account it has in Nedbank only serves as a method to be able to use clearing facilities through the sponsorship of Nedbank, since Baroda is not a clearing bank itself. The amount in the Nedbank account comprises of a conglomerate of deposits and withdrawals by various clients of the Bank of Baroda. Separate accounts are held for those clients, wherein their respective dealings are recorded. The Nedbank account, as such, is therefore not a reflection of the flow of funds of specific clients, but a pool account. The flow of funds for the different individual clients are reflected in separate accounts in the bank, in the books of the bank. The bank does not hold money in the Nedbank account on its own behalf, but on behalf of their clients. According to the bank, to investigate the Nedbank account and draw conclusions from that is therefore inaccurate, misleading, and unreliable. According to the bank, that is exactly what Mr. Muradla did. In any event, on Mr. Muradla's own account, the 30 million rand, in regard to which a preservation order is sought against the bank, was transferred to a call account 3 days later and did not remain in possession of the bank, nor reflected as a remaining balance in the Nedbank account. In the same way that preservation orders are sought in respect of specific accounts of affected entities in other banks, if a preservation order is sought, it should seek to preserve the account of the specific clients, affected entities held by the bank, and not the Nedbank account of the bank itself. I cannot fault the bank's reasoning. Moreover, as will be shown later, the conclusions reached by Mr. Muradla are based on a selective reading of the account in Nedbank and in instances demonstrably unsubstantiated. As far as the other affected parties are concerned, the preservation orders sought against the other affected parties largely rely on Muradla's investigations and conclusions. I do not intend dealing with each of the tranches that he referred to and the alleged flow of funds in regard to each transaction relied upon by the applicant. A few examples should suffice. As far as tranche 1 is concerned, for instance, on the 19th of April 2013, Estina deposited 10 million rand into the Nedbank account of Baroda. Mr. Muradla then avers that the 10 million rand was transferred to Oak Bay Investments on the same date. However, the copy of the account handed in by Mr. Nsumutsi shows that only 5 million rand was paid to Oak Bay on that date. Secondly, on the 20th of April 2013, Estina deposited an amount of 24.95 million rand into the account. According to Mr. Moradla, 18 million rand of that money was transferred to Aerohaven and 4.5 million to Oak Bay on the 22nd of April 2013. On page 2 of the copy of the account handed up by Mr. Nmutsi shows that on the 22nd of April 2013, Oak Bay itself deposited 10 million rand into that account, and a further 28 million rand was deposited into the account from a call account. There is no rationale and rational basis for concluding that the amounts paid to Aerohaven and Oak Bay stems from the Estina deposit and not from the other deposits. Thirdly, as far as tranche 4 is concerned, it is alleged that on the 20th of December 2013, Estina deposited two amounts of 5 million rand in a total of 10 million rand in the Nedbank account. On the same date, West Dawn Investments deposited 42.6 million rand in total, and another 40 million rand was deposited in that account from a call account. An amount of 38 million rand was paid to Mr. A. Gupta. Moradla concludes that the 10 million rand deposited by Estina forms part of that payment to Mr. Gupta. It's not clear why he comes to that conclusion, and why not find the other deposits made as the origin of those monies, namely the deposits by West Dawn or from the call account. Tranche 5, it is alleged that on the 30th of July 2014, 5.5 million rand was paid into the Nedbank account by Estina, and Mr. Moradla then alleges of that money, 6 million rand was paid to West Dawn Investments and 3.2 million rand to Aerohaven. That is 3.7 million rand more than the amount paid in by Estina. The arithmetic does not add up. Lastly, on the 18th of August 2014, an amount of 8 million rand was paid, and on the 19th of August, another 7 million rand paid from Estina into the Nedbank account. The total being 15 million rand. Mr. Moradla then asserts that the following payments out of that account forms part of those deposits and thus constitute tainted money. Namely, to Oak Bay Investments, 10 million rand, to Annex Distribution, 6 million rand, to Island Site Investments, 5 million rand, to Oxolo Diamond Cutting Works, 4.5 million rand, and in total thus 25.5 million rand, 10.5 more than the amounts deposited by Estina. Again, the sum does not add up. What is more, before those payments are recorded, inter alia Annex Distributions paid 11 million rand into the same account, and another 10.7 million rand was deposited from another account. The above mistakes and omissions in Mr. Moradla's evidence cast serious doubt on the reliability of his findings. It does not end there. The Bank of Baroda annexed the account of Estina held in the bank. That account was not disputed by the applicants in its answer to the Bank of Baroda's affidavit. Although the account records all the payments and transfers made by Estina into the account, it does not reflect any of the alleged payments to the affected parties. It can be noted that the flow of large amounts of monies in and out of the Nedbank account is suspicious, but suspicious, unfortunately, is not sufficient to found a preservation order. The entities in regard to whom preservation orders were sought exclusively because of payments from the Bank of Baroda net bank account are the following: Atul Gupta, Oakbay Investments Pty Limited, VRLS Investments Pty Limited, Uxolo Diamond Cutting Works Pty Limited, Island Site Investments 180 Pty Limited, West Dawn Investments Pty Limited, and Next Distribution Pty Limited. The larger part of payments to Aerohaven Trading Pty Limited, with the exception of 73,277 rand and 24 cents, also stems from payments out of that net bank account. Aerohaven and Linkway Trading Pty Limited also filed a notice to apply for exclusion of the respective amounts paid to them from the operation of any forfeiture order. In the case of Linkway, the draft order initially presented by the applicant and granted by me is clearly wrong in preserving an amount of 6 million rand. Linkway only received 157,320 rand. No application for forfeiture has as yet been made, and the question of exclusion will be dealt with if and when such application is made. However, it implies at least admission of receipt of the aforesaid amounts. At least as to those amounts, the preservation orders should stand. It is necessary to deal with the position taken by the curator bonus appointed in terms of the initial order. In respect of the powers afforded to the curator bonus, it was argued on behalf of the affected parties that the powers set out in the order granted by me exceeds the powers provided for in Section 42 of the Act. In terms of Section 42(1)(a) of the Act, the court may appoint a curator bonus to do, and I quote, subject to the direction of that High Court, comma, any one or more of the following on behalf of the person against whom the preservation of property order has been made, namely, semicolon, Roman 1, to assume control of the property, Roman 2, to take care of the said property, Roman 3, to administer the said property, and to do any act necessary for that purpose, and Roman 4, where the said property is a business or undertaking to carry on with due regard to any law which may be applicable, comma, the business or undertaking, semicolon, and B, order any person holding property subject to the preservation of property order to surrender forthwith or within such period as that court may determine, comma, any such property into the custody of the curator bonus, unquote. In this regard, it was argued that the orders, as it stands, allows the curator bonus to search for funds and accounts not specified in the order, and then preserve such funds or accounts to the amount specified in the order. That argument holds water as far as identifiable, movable property is concerned, but due to the nature of money itself, loses sight of the fact that, comma, once received by a person or entity, it loses its separate identity and becomes part of the totality of funds held by such receiver. To expect of the DPP to show that the specific tainted money still exists and is located in a specified fund or account would require proof of the impossible and defeat the purpose of the Act. Once it is proved that a receiver has received a certain amount of money forming the proceeds of crime, the preservation of money to the extent of that amount can be audited, regardless of which fund or account of the receiver is involved. If that was not so, a receiver of tainted money would be able to simply allege that that money was already disbursed and any money remaining in his possession thus not subject to preservation. That is totally unacceptable and anomalous. As far as the powers conferred on the curator bonus in terms of the order are concerned, I remain unconvinced that those powers are ultra vires and exceeds the powers provided for in the Act. Section 42, 1A, Romans 1 and 3 empowers the curator to assume control over and administer the property and, importantly, to do any act necessary for that purpose. The powers granted in terms of the order goes no further than that. However, it is prudent to amend the order to avoid uncertainty as to that position. A more vexing question relating to the curator is the position of the curator bonus in this matter in view of the stance he has taken, especially in relation to costs. In its answer to the Bank of Baroda's application for reconsideration, the National Director of Public Prosecutions raised an objection in limine to the effect that the curator bonus should have been joined. In an email, the curator bonus indicated that he was of the same view. Without conceding the necessity of that, for purposes of an application for reconsideration and for the sake of expedience, the affected parties consented to the curator being joined as a party. The curator then filed an affidavit partly dealing with the results of his investigations and factual issues pertaining to funds preserved and accounts of some of the affected parties. He, however, saw fit to, in that affidavit, comment on the authority of the deponent, Rabagan, to act also on behalf of the affected companies. He commented on the merits and demerits of the applications for reconsideration and even praised for the applications for reconsideration to be dismissed. He clearly made common cause with the DPP. In view of that, he was requested by the affected parties to withdraw his affidavit on pain of an order of costs being sought against him. He refused. The curator bonus's affidavit was filed on the 26th of February of this year. Heads of argument on behalf of the curator was signed by his counsel on the 27th of February and filed on the 28th of February of this year. A notice to abide was filed by the curator on the 27th of February of this year. The first part of the heads of argument on behalf of the curator deals with the question whether the powers conferred on the curator in terms of the order are ultra vires or not. The rest deals with the merits of the matter. It does not deal with the question of cost at all. Notwithstanding the notice to abide, Mr. Lotz appeared for the curator during the hearing of argument. The duties of a curator bonus in connection with preservation orders are to locate, take control of, and administer the preserved property. That he has to do objectively and impartially. His additional duty to report to court requires an objective and impartial report on factual issues concerning the performance of his functions. His views as to the merits or demerits of the application are, in general, irrelevant. Insofar as he might have discovered factual information that might have a bearing on the merits, that should form part of his factual report. His opinion and views as to the effect thereof on the merits, however, remain irrelevant. In short, he should refrain from entering the arena. The curator bonus's notice to abide conforms to the above principles. His affidavit, however, insofar as it deals with his views as to the merits and his briefing of counsel to argue those views, do not. I was asked to show my disapproval of the curator's interference in the merits of the application by means of a special cost order. I'm not convinced that the joinder of the curator was necessary at the reconsideration stage at all. However, his joinder was partially brought about and initiated by the stance taken by the applicant in its answer to the application for reconsideration of the Bank of Baroda. Part of the blame for that should be accorded to the applicant itself. However, as shown above, the curator bonus overstepped the bounds of his duties and moreover chose to blow hot and cold simultaneously by filing a notice to abide but still saw fit to brief counsel to argue the merits. I acknowledge that part of the attack against the orders granted by me was aimed against the alleged ultra vires powers of the curator bonus. The curator has a sufficient interest in those powers affecting the performance of his duties to be allowed to respond thereto. Part of his affidavit and the argument on his behalf dealt with that. If he wished to limit his response to those issues, he should have done so and not filed a notice to abide. Considering all the above factors, I am of the opinion that the curator bonus should be held responsible for at least part of the costs occasioned by the filing of his affidavit and the employment of counsel to appear during argument on his behalf. I will provide for that in the orders that I propose to grant. As to costs in general, all the parties except the Bank of Baroda and the curator bonus employed the services of two counsel, justifiably so. The papers are voluminous and the issues of great importance to all the concerned parties. Although Airhaven is only partly successful, it is substantially successful in its application for reconsideration. In conclusion, I grant the following orders, some of which aimed at rectifying mistakes in the original order. I may just mention that the orders that I make is contained in a draft, which will be available after the court adjourns. It's not necessary to note it down at this stage. The following orders are granted. Paragraph 1. Paragraph 1 of the order granted on the 18th of January 2018 is amended by deleting the word, quote, immovable, unquote. 2. The amount in paragraph 1.2 of the order and paragraph 1 of Annexure A to the order is amended by substituting the amount of around 40,360,154 rand 98 cents in place of the amount of around 220,202,652 rand. 3. Paragraph 1 of Annexure A to the order is further amended by deleting the words, quote, which constitutes proceeds of crime, unquote, and adding the words, quote, or in any fund or account held by or on behalf of them, unquote. 4. Paragraph 12 of the order granted is amended by deleting paragraphs 12.3, 12.5, 12.8, 12.9, 12.10, 12.12, 12.13, and 12.16. 5. Annexure A to the court order is further amended by deleting paragraphs 1.4, 1.6, 1.7, 1.9, 1.10, 1.11, 1.12, and 1.13, and by adding the following at the end of paragraph 1.15, quote, an amount of around 19 million, unquote. 6. Paragraph 1.5 of Annexure A to the order is amended by substituting the amount of around 73,277.24 in place of the amount of 21,273,277 rand and 24 cents. 7. Paragraph 1.14 of Annexure A to the order is amended by inserting the amount of around 157,320 rand in place of the amount of around 6 million. 8. The paragraph numbers in paragraph 12 of the order as amended and Annexure A to the order as amended are renumbered to run consecutively. 9. The applicant is ordered to pay the costs of the affected parties, being the applicants for reconsideration, including the costs occasioned by the employment of 2 counsel where so employed. 10. The curator bonus is ordered jointly and severally with the applicant, the one paying, the other to be absolved, to pay 50% of the costs occasioned by the filing of his affidavit and employment of counsel, de bonis propriis. 11. The amended order annexed hereto is confirmed. Court adjourned.
All rise.